recognise.
My lady, my lords. The as just a final point on ground one, my learned friend pointed out to me after you rose that in respect when I gave the statistics that we had calculated as to the paucity of responses on the first limb, I hadn't gone on to give the calculations on the second limb, which are somewhat different. Very happy to do that. So there is on the second limb the test of secure and effective convenience to local government. The Home Office considered 1,479 responses out of the 7,000 addressed that question, and considered that 6,269, the final question of whether it reflects the identities and interests of local communities. For your note, it's paragraph 72B of my learned friend's discussion.
Thank you very much.
That is, unless I can assist any further on ground one, I propose to turn to ground two. And in my submission, ground two is, at least as I've understood it, really a challenge to Mr. Justice Swift's ruling, which is encapsulated at paragraphs 27 to 28 of his judgment, which is where he identifies repeats his conclusion, paragraph 27, as to what the consultation must include by reference to the statutory context, which I think is now in agreement has to be considered. And then his conclusion at paragraph 28, which he obviously then goes and gives reasons for, follows that the content of this conclusion, the information provided in this consultation falls well short of the mark. And my submission, before I get to the substance of ground two, we would submit that if ground one fails, then this appeal fails, and ground two doesn't save it. And the reason we submit that is my learned friend, at least on my note of his submissions, accepted that if the court accepts Mr. Justice Swift was correct, that the consultation had to engage the public on the statutory tests in section 113. And if, as a consequence of that, the consultation had to provide some information as to the Secretary of State's views on the statutory tests, which we submit is the logical consequence, and indeed is clear from all the authorities, then the consultation is unlawful. And so, if my learned friend's concession there is right, and my note is right, then it's not saved by ground two if you didn't ask the right questions in ground one. And in my submission, that must be right, because otherwise you are predicting, you are trying to predict what the 7,000 people would have responded to the correct questions, or the correct information, or the detailed information, which would be if they were asked to engage in the statutory tests. To say, well, we didn't ask them, but effectively all their responses would have been the same or thereabouts, and so it doesn't really matter. But that is just an exercise in speculation, and it is not in our submission, cannot therefore save the legality of the consultation. And so therefore, our primary submission on that is that the ground fails and this appeal fails. Turning to ground two and to the consultation itself, that is, as we've seen in the core, and at page 200, the executive summary starts at page 250 of the core bundle. One point by way of reply before getting into the substance. My learned friend submitted that there was, for those who aren't digitally engaged, which may, as my lady and my lord observed, be a significant portion of the population, there was a helpline available for ask for the relevant documents. Well, unless we've missed it, you have to embark on the treasure hunt to find that helpline. And there is no phone number, as we can see, in the consultation document. There is no helpline. All that there is an option at page 254 to, if you have any complaints or comments, to write to the Home Office at the above address. This was, of course, to write to the Home Office to obtain, therefore, the underlying material that they are referring to and relying upon, and then to have that material returned to you by the Home Office, and enough time for you to then consider to provide an intelligent response to the consultation.
Well, there is also 256 in fairness to them, if you will say it's the same thing. Any inquiries regarding this publication should be sent to us at.
Yes. So
there's no phone number.
No phone number.
Yes. It's not, to be fair, it's not just 254.
Sorry, correct, but it's the same address.
Yes.
Yes. But they, yes, although they provided two addresses twice. But of course, question mark whether that ever would be sufficient. But this was, as my lady observed, a consultation conducted at pace over Christmas and New Year. Indeed, it was done over 27 working days. And so this written correspondence that has to be engaged with in order to obtain the relevant information that the Home Secretary is relying on is being conducted by post in 27 working days. And respectfully submit, it's simply unrealistic to think that that is a sufficient means of ensuring that individuals who want to engage in consultation have the relevant information to do so. Mr. Justice Swift was entirely correct that a consultation is not the beginnings of a treasure hunt to enable someone, however well versed they are, and or whether or not they've got connection to the internet or not. Turning to the consultation itself, my learned friend submits that it was sufficient to identify the broad benefits of the proposal, and then to allow the consultees to comment on those broad benefits, and then to allow the Home Office to do the work of identifying how they fit into the statutory tests. But what Justice Swift found or concluded in his judgment was that even those broad benefits are so broad and to be almost entirely unexplained. At paragraph 24 of our skeleton argument, we've identified them, that they are those at the broad benefit at paragraph 3 of the consultation, and in the middle of that paragraph, part 1 of the government's review into the role of PCCs cemented the view that bringing public safety functions under the leadership of the combined authority mayor has the potential to offer wide levers and a more joined-up approach to preventing crime. One asks the rhetorical question, well, what does that mean? Indeed, by Lord Dingemans asked, what does wide levers mean? It is not answered by paragraph 7. It is entirely unexplained. And indeed, that is Mr. Justice Swift's conclusion at paragraph 28 of his judgment. But there is a reference here to the PCC review, which is the basis of this apparent conclusion. We now know that the PCC review is not publicly available, and if we knew that below, then that's my failure in recollection. But if we now know that it is not publicly available, so it couldn't be found on a Google search, which makes even more important Mr. Justice Swift's conclusion that therefore you should explain the rationale of what it is that it found and why it is that it found. And that information was obviously available to the Home Office, and we can see that by turning to the assessment of the statutory questions, which was Annex A to the submission, and it's in the supplementary bundle. And we could turn to the supplementary bundle at paragraph 32.
I'm sorry, which page?
Sorry, page 32, not paragraph, page 32. My lady, you'll see that the first substantive paragraph on page 32 is a relatively detailed analysis of the conclusions of the PCC review, focusing on areas in Manchester and London where there was considered to be a greater recognition by the public of who their mayor was as opposed to who they compared to areas with PCCs. And that was used as part of the justification under the test on the preceding page of environmental well-being. And so the point is, which Mr. Justice Swift accepted in the court below, is that this information was in the knowledge of the Home Office, or at least certainly could have been in the knowledge of those compiling the consultation document. And so when in the consultation they're relying upon the PCC review as having identified a mayor has the potential to offer wider levers and a more joined-up approach to preventing crime, then that needs to be explained. And if it's justified on the basis of the percentage, the fact that the public know who their mayor is and not who their PCC is, and therefore the mayor has more influence, then that needs to be set out, because that would enable those living and working in the West Midlands to address it and say, for example, well, actually, we know very well who our PCC is because he is very active in the area, and we know that. And we don't consider that it's necessary, or we do consider that it's necessary. I don't know who my PCC is, and I do know who the mayor is. The wide range of responses could come forth that would inform the Secretary of State's decision. The other point, whilst we have the document open that Mr. Justice Swift relied upon at paragraph 29, is the consultation document also relied upon, or at least cited, the fact that the transfers had been carried out in other areas, including Manchester and London. But again, as Mr. Justice Swift observes at paragraph 29, the relevance of that in the Secretary of State's view is again entirely unexplained. But if we look at these statutory answers and look, for example, at pages 30 to 31, starting at the bottom of page 30 and going all the way over to 31, there is a little more detail as to why they consider Manchester and West Yorkshire to provide evidence of benefits under the test and heading of social well-being. And then at paragraph 34, there are two paragraphs focusing on Greater Manchester's crime plan, 2022 to 2025, and the collectiveness that places on bringing together different organisations. So all of this information in a lawful consultation addressing the statutory tests could have been put forward. Instead, all that was set out was a reference, which we respectfully would submit is to a layperson and entirely unclear, to the ability of the mayor having wider levers than a PCC. The only other benefits identified in the consultation is at paragraph 7. But again, beyond stating that it provides an opportunity to align policing crime priorities with transport regeneration skills and to improve outcomes for the public, there's just no explanation.
Well, as I said this morning, these are broad statements.
They are very broad statements. And if these are meant to be the broad benefits on their case, which enables an intelligent response to the question the Secretary of State is meant to be deciding, which then enables the Home Office to do the work of deciphering those responses and applying them to the statutory tests to save the consultees for having to have done that themselves, these are far too broad, far too unexplained to provide that basis. And that's what Mr. Justice Swift concluded in 29 and onwards, and his conclusion at 28 that it simply falls far short of the mark. And we've, I've already made the point in response by Lord Justice Dingemans' question earlier that, in fact, we know from the statutory questions, and this was highlighted in relation to the Thameside inquiry point in the judgment, that the Secretary of State did consider that as part of the economic well-being, there was the financial breakdown, the relevance of the financial breakdown, whether or not there would or would not be cost savings. And I've already summarised, and unless it's this, I won't go into fact that once you take into account the employment of a deputy mayor of policing to do the PCC's functions, there is no such statements, and if all that had been identified, then there would be a clear route and a clear basis upon which the consultees could engage with the questions that the Secretary of State himself thought were necessary when he was carrying out the statutory tests. My lords, when you look at the 11 pages of reasoning as to why these statutory tests were conducted, significant amount of information, as Mr. Justice Swift accepted his judgment, doesn't originate from the consultation responses. So it was in their mind, or at least it could have been in their mind had they turned their mind to it. And the fact that they hadn't turned their mind to it because they were trying to think of a way to secure the transfers before the May elections doesn't absolve them from the duty of doing a lawful consultation. And they should have done it and should have put the information forward. So the overarching submission, as we set out in the skeleton argument, is that Mr. Justice Swift was right that this consultation falls far short of the mark in terms of the information. It fails to seek any information about how it's going to impact the local people in the West Midlands. It fails to provide any views of the Home Office as to why it would be or wouldn't be a benefit to the people in the West Midlands. And it fails to include proper financial information as to the financial costs or benefits of, we would say costs, of the transfer. Fails to accurately explain the role of the Deputy Mayor of Policing, that in fact you are transferring the PCC, whose full-time job, to a mayor who's then going to give most of the powers to a Deputy Mayor who's not directly elected. And for all those reasons, this consultation just didn't even start in our respective submission to be a lawful consultation. Even if it was simply the case that all it had to do was provide a generic summary of a wide discretion that the Secretary of State had to make an order, which of course he didn't, because he was actually bound, as much as he didn't want to be, by Section 113 of the 2009 Act. And so his submission only wins, in my submission, if my learned friend succeeds on ground 1 and establishes that in fact all you needed was a wide discretion, and you only had to consult on that broad discretion of is this a good idea or is it not. But even if you are just consulting on that broad discretion, this is still woefully inadequate, because apart from two very broad overarching statements that aren't particularly clear to a layperson in any event, why levers is a phrase that still escapes me, then in my submission it falls short of providing, even on that other basis, a sufficient consultation. Those are the points that, in addition to those in our skeleton arguments, that we would make on ground 2, unless there's anything in particular that
you've done it in time.
Done it in time.
Thank you very much. Mr. Payne.
My lady, I think it's important that I clarify my client's position on section 113. Can we just take up section 113? The authority
Page 19, isn't it?
I think so. So we had a lot of discussion this morning about the word proposal, the concept of proposal, and that obviously that's a word that features in section 112A. Now, if we look at 113, 1A, what is referred to there is the need in terms of Secretary may make an order, so it provides the power to make the order under 107F, and then if you look at paragraph 2, subparagraph 2, it says the Secretary must carry out a public consultation, and then unless. So all that's required under 113 is no requirement for a proposal. It is simply Secretary has to undertake a consultation before making an order under 107.
I did ask you precisely that question this morning. It was one of the first questions I asked. You said proposal, and I understood that to be a shorthand for proposed course of action. It must be a consultation on something. It's not a consultation on the bus routes or anything like that. It must be a consultation on something. Parliament must have intended them not to go through a meaningless exercise. So the question is, what is the exercise that Parliament intended them to go on?
And this is the Secretary's position. A minister or the minister can think about something which, think about, for example, think about a police transfer and think, well, that's a good idea. I think there are these benefits that could arise from a police transfer, a transfer of the policing functions. He could then say, right, well, I'm going to consult on that proposed transfer. And so long as during that consultation the Secretary of State sets out the reasons why he thinks it's a good idea and the statutory conditions that he will apply in making that decision, that is compliant with Section 113. So you can have well, let's take the fact of this case. The Home Secretary obviously thought in making the 6th of December decision, thought it was a good idea to transfer the functions of the PCC to the Mayor. And he did so without obviously thinking about the conditions or criteria in Section 113. He was entitled then to take the view that he'd taken, that it was a good idea, consult on it, set out the criteria he was going to apply in making the decision, and then look at the information obtained during the consultation, apply the criteria, make the decision. And there's nothing in Section 113 that requires a different approach.
It all depends on the construction of 113, 2 and 1. And when they said they must carry out a public consultation, did Parliament intend to leave a broad discretion? So you could consult on, I think it might be something I might want to do at some stage. Or was Parliament thinking, at some stage, the Secretary of State is going to propose a course of action, the transfer of policing, which you can only do in certain circumstances. And what Parliament intended was that there be a consultation on that proposed course of action. That's clearly what A, B and C are referring to in the context of a 112A proposal.
But you can, Marlon, don't we come back to what do we mean by proposed course of action? Because the proposed course of action is to transfer the
proposed course of action is putative exercise of the power conferred by Section 107F, bearing in mind the conditions that must be met in A and A and B.
But, my Lord, I think that the difference between us is that the Secretary of State's position is that you can consider a proposed course of action, so for example, transfer the police functions, and you can consider, or the Minister can consider that, and it has some benefits, and you can do that, consult on that, and then apply the conditions.
Yes, that's your case, but the question is that what Parliament required?
But as well, is it not the? I think isn't it the other point, which is that does Section 130 on the interpretation, does that preclude the Secretary of State from that approach? And does it require the Secretary of State to have considered the statutory test before consulting?
Yes, that's the question.
But we say that if you look at the statutory purpose and you look at the Secretary of State, if you look at a process whereby the Secretary provides the reasons and the criteria which are going to be applied and invites comments, there is no reason, we say, why that wouldn't fulfil or achieve the statutory purpose. Because ultimately, the design or the purpose and object of the consultation is to give the Secretary of State information which can then be relevant to exercise of his discretion. And it doesn't need to be limited or anyway constrained to the conditions, because I think, as I said this morning, the Secretary could look at the information and not even get to the conditions, or look at the information, get to the conditions, but nevertheless decide not to do it.
Am I right in thinking that you're submitting that he must at least refer to the criteria as part of the constitution? So he sets out his reasons for why the transfer is, in his view, a good idea, and you say he must refer to the criteria, even though you wouldn't have decided yet whether or not they're met.
Yes, because he gets exactly that. So he refers to his reasons or the benefits, the criteria. So effectively, he's saying to those who are consulted, these are the benefits, I think. This is ultimately what I'm going to have to apply apply when I decide. Can you give me some, please give me your
That's going to
views.
be my next question. Doesn't he have to give such information as he reasonably has available about the criteria? If the whole exercise is to enable, as I thought you were now saying, that they must be able to comment on the reasons for the transfer and on the criteria when the Secretary of State comes to decide if they're met. Surely the Secretary of State, if it's going to be a meaningful exercise, has to give such information as to enable members of the public to comment meaningfully on the criteria. Say there are these statutory criteria, please tell us whether you think they're met or not. Is that what Parliament intended?
No, but the consultation isn't about inviting consultees to express views as to whether statutory conditions are met. That's a matter for the Secretary of State or the Home Secretary to decide whether conditions are met. The consultation is to enable the public to know about the reasons why the Secretary is considering the transfer, know the conditions that he's going to apply in making the decision, and enabling the consultees to express their views on it. I mean, I accept that if, I think as the case in the Devonshire case, that if you, because in that case, that was also about statutory criteria that were set out in the consultation, and the court found it was unlawful because effectively what happened was the subsequent decision was taken by reference to different criteria. But all you need to do in order to achieve the consultation goal is to enable people to know what the ideas are, how the Secretary is going to take his decision, and comment on those ideas. And as I said, I think this morning, it is perfectly, and my own friend makes this point, if the information provided is inadequate, and I think by that, what's meant is that the reasons that are given, or the justification that's put forward, or the benefits that are identified, aren't adequately explained and aren't sufficient, then members of the public, those consultants, could say, well, I've looked at these reasons. I don't think that they, based on those reasons, I don't think either they're sufficiently explained or they're sufficiently compelling to justify a transfer. And that is the purpose of a consultation.
All right, can I just get this clear? Because it feels to me, and I'm sure I'm wrong, that you're slightly shifting your ground from this morning. Yep. This morning you told the court very clearly that the benefits are for the public, let me use that word generally to comment on, whether those benefits meet the criteria is for the Secretary of State. That's what you said to me in answer.
Yep.
You said the benefits are set out in paragraph 3 and paragraph 7 of this document. So when now you've been speaking of the consultation is to allow the public to know the reasons for the transfer, for reasons, is that what you were describing as benefits this morning?
My lord, yes, and perhaps I shouldn't have. Well, I shouldn't
Well,
have used
it
the
didn't
words
assist, to be fair, Mr. Payne, but everyone's doing this under pressure of time. I wholly understand, but that's what you actually mean.
Absolutely, I'm talking
All
about
right.
benefits through
Yeah.
reasons. I should have.
Thank you.
I'll stick to the words.
Logically, you don't even need to refer to the criteria because there's criteria for the Secretary of State. On your analysis, the key issue is you've got an idea that you're going to transfer. You think that's going to have benefits or there are reasons for it, and they need to consult on the idea, if you like, not the statutory criteria. You don't even need to tell them the statutory criteria.
With respect to, I don't think the Secretary doesn't agree with that because because you could have a process whereby or a decision making process whereby the Secretary of State has formed a preliminary view on the criteria, has a consultation sort of setting out those views or benefits, and then inviting comments.
Yes, but that would be a choice. The question at the moment is that Parliament has actually set out a requirement, and we're trying to work out what the minimum requirements of that are.
I agree.
If the Secretary of State decided to do more than the minimum required by statute, that's a matter for him. At the moment, we're trying to work out what the words in 132 mean. And as I understand it, really, you don't even need to refer to the criteria because this isn't a public consultation on the criteria or whether the proposed course of action would meet the criteria. Therefore, you don't need to provide any information on that. The words carry out a public consultation means simply a public consultation on an idea that he has that he might transfer and to set out why he thinks that would be a good idea.
What I was trying to say, my lord, was that if the Secretary of State hasn't taken the option of reaching a view on the, at least a preliminary view on the statutory criteria and then consulting, if instead he's consulting at an earlier stage, then we would accept that in terms of the consultation, those consulted need to be given an indication of what the criteria are when the Secretary of State makes that decision. Because in the first example, the Secretary of State will have applied his mind to the criteria and will be recording in the consultation document his views on the criteria. In the second example, the consultation takes place at an earlier stage in the process. So at that stage, it's the potential benefits that have been that are considered will arise, which are being consulted on, with the criteria that will be applied indicated at the end, so that those consulted can comment by reference to the criteria on what the...
So the consultation exercise must, as a matter of law, require provision of information about the anticipated benefits and refer to the statutory criteria.
Yeah.
Can I just ask you for your answer to the submission that Mrs. Sansfeld made, which was that members of the public would have no genuine opportunity to take part in the Secretary of State's decision-making unless the consultation document identified the Secretary of State's provisional views on why those statutory criteria were satisfied?
Well, my answer to that is that the public, in terms of engaging with the decision-making process, the opportunity the public need to be given is to comment on or express their views on the benefits the Secretary of State perceives would arise from the ultimate decision, if it were to proceed, but doesn't extend to an opportunity to comment on the Secretary of State's reasons why the statutory criteria are the preliminary reasons as to why the statutory criteria are met.
Thank you.
Can I quickly turn to one other point is that I think I've got 3 more points to make. So the first point is that, just to go back to the point I made at the outset of my submissions, that Mr. Justice Swift didn't find that the consultation was unlawful because of a lack of questions or the fact that questions weren't asked. It was about lack of information. Because my own friend, in terms of the submissions that were made, referred on a number of times to the fact that it was a lack of questions, whereas it's a lack of information. Now, in terms of the information, can I just ask you to turn up the case of Mosley, that's tab 12. And so, if bottom of 301, the point is made to the extent that the issue is left open by the relevant statutory provisions. The question will generally be whether, in the particular context, the provision of such information is necessary in order for the consultees to express meaningful views on the proposal. And then at the top of 302, in the present case, on the other hand, it is difficult to see how ordinary members of the public could express an intelligent view on the proposed scheme so as to participate in a meaningful way in the decision-making process unless they had an idea of how the loss of income by the local authority might otherwise be replaced or absorbed. So the point I'm going to make here is that in Mosley and in cases where there's an insufficiency of information, the courts identify the information that is necessary and wasn't included. And so here, in this case, you have the alternatives, and that's the information that was necessary and wasn't included. Now, in this case, and also, sorry, that the information was of sufficient importance or centrality to the consultation that it needed to be included. Now, in this case, neither Mr. Justice Swift nor my learned friend has actually identified, or certainly, well, Mr. Justice Swift hasn't identified information that was available to the Secretary of State, wasn't included, and the absence of that evidence was such so as to render the consultation conspicuously unfair. Or put it another way, my Lord Justice Lewis said that that information was necessary to discharge or comply with the Section 113 obligation. All that said is that there was some information available in the annexes which went beyond the responses and could have been provided. And unless you identify the information that wasn't provided, then it's difficult to see how you can rationally or reasonably reach a conclusion that insufficient information was provided. My learned friend raised two matters from the report, and it was, I think, a failure to provide information suggesting that or indicating that there was a much larger percentage of people who recognised the mayor than the PCC, and to provide details as to some of the positive consequences for GMP in terms of the transfer. Those two issues might well be relevant, but are relevant or potentially relevant. But you cannot say that those two pieces of information, the absence of that information, is such so as to undermine the process, or the inclusion of that information was necessary in order to discharge the consultation obligation under Section 113. I mean, in essence, sometimes in relation to the questions I was asked by the court and the points made by my learned friend, the criticism is almost, well, that the Secretary of State's position or reasons for pursuing the consultation were inadequate. But that's a very different point, because first of all, it sort of didn't form part of the challenge. It's not part of Mr. Justice Swift's judgment. But the fact that the Secretary might have limited reasons or limited justification or have identified limited benefits, that's very different from saying, as in the case of Moseley, well, there's this other information that should have been included that wasn't. I mean, one can only expect the Secretary of State to put forward the benefits that the Secretary of State's identified, and the fact that there aren't more benefits that they've identified doesn't render the consultation process unlawful. Because, as I've said, it's open to the consultees to say, well, those benefits, I don't really understand them, or they're just not sufficient, and to express their view on that basis. And in terms of the last point, in terms of the points made by my own friend in terms of the specifics, in terms of the information about the potential impact on the democratic role of the PCC by being transferred to the mayor, and the potential for the mayor to appoint a deputy mayor, those were considered by Mr. Justice Swift. He said of themselves it wouldn't suffice. And insofar as there is now, there's a suggestion that there was Secretary acted unlawfully by failing to seek additional information prior to issuing the consultation, we say that cannot be right, and it's certainly not Wednesbury unreasonable. The Secretary to proceed on the consultation on the basis of the information available.
Thank you very much indeed, Mr. Payne.
Thank
Do you want to check behind?
Yeah. Thank you very much.
Thank you. Well, as I said this morning, having heard the submissions in respect of the primary application and the response, we're now going to rise to really consider where we are. Thank you all very much.
Rise.
Mr. Payne, the application for permission to appeal is refused. Reasons will be given at 3:30 or so soon thereafter as the court can do it. All right? Thank you very much.